This is week 13 of Legal Issues in Corrections, and we're going to start the week by looking at jails. This is chapter 20 in your textbook. The text talks about the constitutional rights of jail inmates. The leading case is Bell versus Wolfish, which we've talked about before. The standards set in Bell including because of due process protections, a pretrial inmate may not be punished. He may not be deprived of his liberty without due process of law. And the question becomes how to tell if the inmate is being punished. The court held that the test is if a particular condition or restriction of pretrial detention is reasonably related to a legitimate governmental objective, it does not, without more, amount to punishment. Ordinarily, the objective is security or good order. The court held that crowding with double bunking of inmates in single cells and even sleeping in non-bed areas did not amount to punishment. Conditions other than the number of inmates and the square footage of cells are important. The length of time inmates are held in jail, amount of time spent in cells, are there activities for them outside their cells, does a large number of inmates adversely affect the delivery of other important services such as food, sanitation, and health care? Jail inmates are also protected when other rights protected by other constitutional provisions are implicated, but all may be limited by security concerns. It's permissible for jail officials to limit incoming publications to publisher-only mailings under the First Amendment. For searches, the court upheld jail practices of doing cell searches without the inmate being present, and conducting visual body cavity searches after contact visiting. Jails, along with pretrial inmates, may hold those with short sentences. Example given is a year or less, with exceptions made as needed, such as for a disruptive inmate or an escape risk. Those awaiting transfer to a state prison, the stay may be extended due to crowding at the prison, and those sentenced prisoners who have been returned to court to be tried on additional charges, to challenge their convictions by appeal or by collateral attack, or to testify in another case. Those who are ordered back to consult with counsel or be present for a hearing, those who have been arrested as probation or parole violators and are being held locally pending a revocation hearing, and jails may also house cadre for maintenance and other work. They may have somewhat more than a year sentence and may volunteer to stay at the jail in order to be closer to home or in some cases to have better living conditions. The constitutional rights of convicted persons held in jails are the same as those for inmates in prisons or correctional institutions, which we've been talking about throughout this course. In Bell, the court found that the mail and search issues were governed by the same security and good order concerns. Government policies and practices were valid both for the convicted and sentenced jail inmates and for pretrial detainees. Other constitutional jails, one is visiting. In Block v. Rutherford, the court held it was permissible for a jail to limit visiting to non-contact, and there was a legitimate governmental objective, for example, preventing the introduction of contraband. In Houchins v. KQED, the court said a TV station did not have any right of access to come into a jail to film a story on a jail suicide, and the court restated its holding in Pell versus Procunior and Saxby v. Washington Post. In Grabowski versus Jackson County Public Defender's Office, it dealt in part with jail conditions. Grabowski claimed a Section 1983 violation when his visiting privileges with his girlfriend were revoked and when he was denied telephone and revocation privilege or recreation privileges while a pretrial detainee. The girlfriend was also an inmate at the jail, and the privileges were revoked when Grabowski got into a shouting match with a paralegal and called her a racial slur in the presence of other, mostly black inmates. Jail officials saw the behavior as disruptive and not in accord with special visitation privileges he had been given. The lower court held no constitutional rights were violated. The actions taken were reasonably related to maintenance of jail security and order. The court held that the evidence showed that the loss of privilege was taken for his own safety and not for punishment. Following incident with paralegal, Gorowski was involved in altercations with other inmates, mostly black. A fire was set in the cell and he was threatened. He was moved into protective custody where the privileges were not available. The lower court found good justification for the actions of the prison officials. Again, institutional security, order, safety. Loss of telephone privileges was upheld in Valdez versus Rosenbaum in 2002. Inmate had been identified as the leader of a drug smuggling conspiracy, was being held in pretrial detention, initially in the jail's general population. In this setting, he had access to 4 telephones. The government prosecutor asked that the inmate's telephone privileges be suspended as new indictments were being issued, with 5 new defendants named as well as Valdez. The 5 new defendants were not in custody, and the prosecutor wanted to curtail Valdez's ability to communicate with other persons. He was placed in administrative segregation, allowed to 1 attorney call each day. Visits were not curtailed. He remained in the status for 4.5 months while other defendants were being arrested. He was returned to the population as the prosecutor's request following a release of one of the co-conspirators. Following conviction, where he was given a 30-year sentence, Valdez filed a Section 93 suit alleging the phone restrictions violated his constitutional rights to due process and freedom of speech. Appeals court held that there was no violation. Inmate suicides. This problem is one that at least as pressing as in jails as it is in prison. Constitutional standard for liability is the deliberate indifference to the needs of the inmate. And staff must be on the lookout for suicidal tendencies. This is all pretty much the same as what we discussed in prisons before. The lower court found there was liability when there was a strong likelihood rather than a mere possibility that failure to take a certain action would result in harm to an inmate. Liability was also found in the Heflin v. Stewart County case where a deputy sheriff didn't cut down an inmate who was hanging himself. Deputy wanted to wait for emergency medical staff. No liability was found in Friedman v. City of Allentown, where the officers did not realize there was a suicide risk because of observable scars on the inmate's wrists and neck. In Logue v. United States, the Supreme Court held that federal officials couldn't be held liable for negligence of local jail officials who were holding a federal prisoner who committed suicide. The county jail staff were not agents or employees of the federal government. There could be tort liability if the federal agent placing the inmate in the jail knew there were suicidal problems and failed to notify jail staff. Searches. As noted previously in Bell, the Supreme Court held room searches at the jail were an appropriate security measure. Of course, also upheld the necessity of conducting body cavity searches after inmate contact visits, finding this is reasonable under the Constitution. In Shane v. Ellison, a federal appeals court considered whether the law in 1995 clearly established a bar against searching a person arraigned on misdemeanor charges, absent reasonable suspicion that the person possessed contraband or weapons. Shane was arrested for first-degree harassment, spent the night in custody, and appeared the next day before a family court judge. He was remanded to the NCCC without bond. He was strip-searched upon arrival, and the next morning, prior to his appearance, Shane filed suit claiming the strip search was unconstitutional. The appeals court held for Shane, distinguished Bell as it dealt with after-contact visiting. Arrestees ordinarily don't have notice they're about to be arrested, and thus don't have an opportunity to conceal something. Appeals court, based on prior cases requiring reasonable suspicion, held the law against strip searching persons charged with misdemeanors absent reasonable suspicion was clearly established, and the sheriff was not entitled to qualified immunity. Courts have held there's no privacy to be expected in jail visits, so it's permissible for authorities to monitor, tape conversations between inmates and visitors. In the case of U.S. v. Hearst, the Federal Appeals Court upheld the use at Hearst trial of an intercepted conversation during visiting that Hearst had at the county jail. In the area of legal access, an appeals court held for the government against an inmate's claim that the jail law library was inadequate and that 1 hour per week of access time was also inadequate. The appeals court found materials were sufficient for the time the inmate was held at the jail. A second appeals court held for the government against the civil rights claim of a pretrial detainee who said his incoming legal mail was opened and read. The court held that opening and checking incoming mail without censoring it was not a constitutional violation. In the area of personal injury, the Supreme Court held in Daniels v. Williams that in a suit against an allegation of government negligence causing an inmate to fall on a stairway, mere negligence did not state a constitutional claim against jail officials. For constitutional 14th Amendment violation, an abuse by government officials of their powers would have to be shown. Negligence by government officials would support a common law tort claim. In the area of using excessive force and failure to train in Davis v. Mason County, an appeals court held the county and the sheriff liable for failure to set up an adequate training program for deputy sheriffs. The Supreme Court set the training requirement standard in City of Canton v. Harris. A city or county may be held liable upon a showing that their failure to train amounts to deliberate indifference to the rights of persons with whom officials come into contact. In the Gibson v. County of Washoe, Nevada case, dealt with the officer pulling Gibson over after observing his strange behavior. They found prescription medication in his car. Gibson, unknown to the officers, had an attempt to locate notice out on him by the police. He suffered from manic depression disorder, didn't like police, according to his physician, should be taken to the hospital for emergency commitment. He was taken to jail and the medication was given to the jail duty nurse. The nurse told one officer the medication was used to stabilize a person suffering from mental illness, and the record doesn't show that this information was further shared. Twice during the evening, Gibson slipped out of waist chain. The staff ordered he be moved to a special watch cell. After the second occasion, Gibson resisted and force was used, and Gibson suffered a heart attack and died. His wife filed a Section 1983 claim against the county and several officials, citing 3 causes of action: excessive force, deliberate indifference, and that the deputy's actions resulted from policies, practices, or customs of the sheriff's department which caused or contributed to his death. The appeals court affirmed the lower court finding that no excessive force was used and that deputies were not deliberately indifferent. The appeals court reversed and remanded to the lower court on the issue of county liability. Citing City of Canton, the appeals court said a plaintiff must show 3 things in order to impose liability. First, they must show a violation of Gibson's rights by a county employee. The court felt the jury could find that the nurse was deliberately indifferent. Second, that the county had customs or policies that amounted to deliberate indifference. And in this case, the court felt the jury could find this by a lack of a policy requiring the nurse to take action. And third, that the county could have prevented the violation if it had had an appropriate policy. In Warner v. Grant County, this concerned a Section 93 action brought by 2 female plaintiffs alleging constitutional violations when they were strip searched following an arrest for possessing marijuana. The suit was against the police officer, a private citizen assisting the police, the sheriff, and the county. The private citizen was given qualified immunity and served as the officer's agent. The officer who arrested also received qualified immunity. In directing a strip search be done, he had acted in accordance with the law established at the time. A strip search could be done based on reasonable suspicion, or if a suspect was to go into jail, general population, and the arresting officer had reasonable suspicion the 2 suspects possessed it. additional drugs. The sheriff and county were sued based on allegations they had a policy and custom of not adequately training officers on constitutional arrest and search standards. The appeals court found for the sheriff and county. Grant County had a clear policy that there would be no warrantless strip searches of temporary detainees. That policy conveyed to all of the officers barred conducting strip searches on female detainees because all female arrestees who required confinement were taken to a separate location and were not kept in Grant County. No female arrestees had been held in Grant County for over 5 years. There was no reason for the sheriff or county to think there would be any female strip searches when the policy said there would be none for temporary detainees, and that policy had been consistently followed. The state appeals court overturned an award of $100,000 to the family of a detainee who died in jail from a drug overdose in Brown versus Lee. The detainee, when arrested for drunk driving, denied drug use and was presenting only symptoms of intoxication. The appeals court held it would be unreasonable to require the sheriff to provide medical treatment to every intoxicated inmate in his custody. A major federal appellate decision, Anderson v. County of Kern in 1995, held that severely austere conditions did not amount to violations of the 14th Amendment or 8th Amendment for sentenced persons when it was used for short-term confinement of severely disturbed inmates. The jail had a 10-by-10 safety cell covered with rubberized foam padding and a pit toilet with a grate covering. The cell was used on occasion for temporary holding of suicidal or mentally disturbed inmates who were very disruptive or threatening. The policy required regular 15 to 30-minute staff checks. Placement was reviewed every 4 hours by the supervisor. Even though the evidence showed conditions in the cell were unsanitary and severe, the court found it was needed to deal with a very serious safety concern. The appeals court in Anderson also approved the jail's use of administrative segregation, where the inmates were not allowed to exercise together because of the jail's concern for their safety. The court found that while conditions in isolated segregation confinement were not pleasant, they did not show deliberate indifference. The court did require the jail to have a non-inmate translator to assist non-English speaking inmates at medical and mental health interviews. Other jail cases dealt with claims of improper health care, turned on the court's conclusion of whether staff had shown deliberate indifference. We've talked a lot about this before. This is just at a jail level versus prison. The Court of Appeals held in Bryant v. Mafusi that there was no deliberate indifference when an inmate was not promptly scheduled for an abortion. The court held the fact that the jail officials delayed her letter to the physician requesting abortion appointment only showed negligence. In Cooper v. Dyke, a detainee suffered a gunshot wound during a chaotic condition of jail disturbance. He was examined by a paramedic. The wound was not revealed. The inmate made repeated pleas for medical attention. The police said they relied on the paramedic's examination, that this showed no deliberate indifference. The appeals court didn't agree. It held it was permissible for the jury to find Section 1983 liability, that the police were not justified in relying on the paramedic when the exam had been done under riotous conditions, and the repeated complaints of the detainee should not have been ignored. In Fromater v. Wayne, an inmate alleged constitutional violations because jail officials were deliberately indifferent to his complaints of claustrophobia and agoraphobia. The court held even if there was indifference, no serious medical need had been shown. And this is another aspect of the standard that the inmate must show to sustain an 8th or 14th Amendment claim with respect to medical care. In cases of removing the sheriff, in Beck v. County of Santa Clara, a California court upheld the sheriff's removal from running the county jail due to repeated difficulties at the jail, including adverse court decisions and other legal problems. The removal was made by action of the County Board of Supervisors and approved by court voters in a referendum.